Hello, everybody. My name is Juan Carlos Brando. Thank you so much for joining us today. One more time with the attorney Margaret W. Wong, who has been working on this field for over 45 years. And she has been helping thousands of families every single year working on this specific area of the immigration law. It's not easy, it's a difficult um, area of the law, but however, she has made a way through to stay there for 45 years. So thank you so much for joining us today, and feel free to ask your question. If you have any immigration questions, please just write them down in this live show, or you can call 216-279-3984, 216-279-3984. Hello, Ms. Wong. Good afternoon. How are you doing today?
I'm very good, and thank you.
Thank you so much, Ms. Wong, for having us. And well, I would like to start by asking um, what is the expectation about the deportations or removals of people that have been in proceedings and they were in this DED, deferred executive deportation, something like that. So, are people getting deported right now?
America is trying not to be draconian in deportation cases. So, right now, not too many people are actually being deported, but we need to be careful. Let's not have, um, if you have chances to appeal your cases, you should. If you have chances of not have a criminal record, you should. Keep filing tax returns because as long as we have been a long time resident here, the chances of getting deported is not as high. Right now, though, I noticed the courts, they're very fast on the new arrivals, on having cases on new arrivals, the ones who just came through the southern border. But as far as deportation is concerned, it's not too bad. But let's not pray that you get deported and don't push the court too much.
Thank you so much, Ms. Wong, for this answer. And well, a lot of people are concerned about what's going on in the immigration world. So thank you so much for giving us this information. Don't forget that you can call. The phone number is 216-279-3984, 216-279-3984. Ms. Wong, a person just asked me about the case that they have. They have a kid, a daughter. She is 4 years old, and the mom, she entered on a tourist visa. She's currently in the city of Cleveland, Ohio, and she wants to know if she could file for something else, other some ways to get a visa. They are from Colombia, and they would like to know what they can do in order to stay legally in the United States.
As long as the visa is still pending, you can also always do the extension of a tourist visa. But since the kid is already 4 years old and the mother came to America with a tourist visa, probably she had overstayed the visa. But if the visa has not been overstayed, you can always do an extension or change it to a student visa. Or if you have university level education, get online to get the H-1B. So there are ways to do it. But if the visa already expired, there's very little you can do. But since you came to America legally with a legal tourist visa, when the kid is over 21, the kid can sponsor you for green card.
Okay, thank you so much, Ms. Wong, for this answer. And don't forget that you can call. The phone number is 216-279-3984, 216-279-3984. We have the question of Angela Ray. She says, "Hi, Margaret. I have a question about my husband's CR1 visa process. The NVC informed our inscription of marriage document was marked invalid with no reason listed. The document we submitted was exactly what was listed on the NVC website for our country, Ecuador. I was able to speak to an agent from the NVC, and they said that the title and subtitle are not what they are supposed to be. But we asked her to look clearly at the name of the document, Inscripción de Matrimonio, and she said that, mm, well, um, I cannot read the other part of the question. So if you can.
Right. I think when you say the CR1 visa, I don't know if the case was approved. It seemed like you were waiting for the immigrant visa interview back home. Um, and I don't, so basically it's weird because that means I-130 was already approved. It already went to NVC. You already paid $120 to $325. So normally they would send you a letter saying that everything is completed. You're just waiting for the scheduling. So maybe, but whatever they say, they know what they're doing. So before the immigrant visa call, maybe double check with them. It could be the marriage certificate, and your CR1 means it's a marriage to a green card, marriage to a citizenship for a green card. So if you go back there for the interview after more than 2 years after the marriage, you'll get the IR1, not CR. CR is conditional, and IR is the 10 years. CR is only 2 years. So when you say this IR1 or CR1, I don't know. I don't think it's even approved yet. You may want to double check it. So the question may be, I'm waiting for my immigrant visa interview and visa call for my husband overseas. And I checked the NVC web, and this is what they say. It could be something wrong with the marriage certificate. But wait for the letter. Normally they'll send you an email or the letter to tell you what's wrong. If not, they will say everything okay. You're just waiting for visa call.
Okay, Ms. Wong, they added the other part of the question, um, saying that we need to get a letter from Ecuador saying that this is the correct document. Apparently, the document that was updated in 2010, and the NVC is still using the older version that was from 1979. It has now caused a delay in our case.
I don't think it caused that much of a delay because of the virus. Everything is delayed. Just update the information we find. At least look at it in a positive sense that they are telling you now and they're not telling you after you get to Ecuador for the interview. That'd be embarrassing because that means your husband will wait there for months for the updated documents. At least they're telling you now. Instead of looking at the bad, look at the good.
Thank you so much, Ms. Wong. Well, we have another question coming in here. Hi, Margaret. My husband was adopted by an American citizen by court order. He's using the last name of his adoptive father, when he stayed and studied and worked in the U.S. for 26 years, but he has convicted with a felony and was deported. The immigration revoked his privileged, which are green card, social security, and driver's license. He signed a waiver during his deportation. He is here in the Philippines. Our question: can he go back to the United States? Can he claim his privilege back? Will he be proclaimed?
Let me tell you what I think. This is the type of case I feel very bad because normally it doesn't apply to most Philippines. It normally applies to the Vietnamese, the Laos, because of they came so young that they have criminal records and they were deported before they became citizens. In this case, it's interesting because the adopted father adopted him. Number one, check if he was a citizen to start with, because citizen laws have changed through the years. In 83, he was convicted under two-strike law. Okay, that's a Clinton thing. That 3 strikes, you're one. Number one, do the whole FOIA to check the old deportation records. Number two, get certified judgment entry of the criminal record. I don't know if you were convicted in a state court or criminal court. Number three, I would check that criminal record again because through the years, the criminal laws also have changed. What used to be a CIMT or aggravated felony may not be, or it was updated. So this is a worthwhile case to check everything. Maybe he was already a citizen because of new laws, or maybe that criminal code that he was convicted under is no longer a deportation one. And also check, does 212C apply? Because since then, things have also changed. But do the FOIA for court, do the FOIA for the criminal records, and go from there. That's my advice.
Thank you so much, Ms. Wong. Don't forget that Ms. Wong has offices in 9 cities of the United States in Chicago, Atlanta, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is just one phone number, 216-279-3984, 216-279-3984, Attorney Margaret W. Wong. We have a lot of questions, Ms. Wong, today. And, well, we're doing it very good. Hi there. I have a green card, and during COVID, I stayed in India for more than 6 months, and I couldn't travel due to travel restrictions. I wanted to know if my stays in the US prior to COVID can still be counted
Yes.
towards my 30 months.
Yes, that's a very good question. As long as you have not stayed outside of America for more than 1 year and 1 day, all those days counted. So I presume you're back here in America now, or if you're not in, hurry up and stay here. Because as long as you're here for every time you leave the country, as long as you didn't stay out 1 year and 1 day, every day counts. So come back, hurry up. And then it'll count towards your 5 years.
Thank you so much, Ms. Wong. Don't forget the phone number, 216-279-3984, 216-279-3984. Irvin Sanchez Troches says, hello, my lawyer. How a wonderful day. Or have a wonderful day. Thank you so much.
Thank you.
Okay, so, well, this is the question that we just answered about the green card, and during COVID, this person stayed out there. And this next question, hello, can we submit case inquiry for siblings visa file in 2016 since haven't got approval yet, but just received a receipt letter
I
in
would
2016?
not, as long as you already have the receipt notice, and every time you move your house, you make sure immigration knows. You do the AR11 on the USCIS.gov and write them a letter with your receipt. Normally, my position is not to push it because quota not open anyway. And the longer you don't push it, the longer the children of your sibling can get green card. So for example, my nephew is already 17 and I filed for my brother in 2016. So your nephew could conceivably even get the green card under your case, even when he's 30 years old, because you deduct the aging out after they're 21. So I would not push it. That's my advice.
Okay, thank you so much, Ms. Wong. And talking about this process, we have another question coming from Camilo, and he says, Ms. Wong, can I get my case expedited if the NVC wrongly marked one of my civil documents as invalid, even though it is the one required by them and listed on the NVC website under required civil documents for my country? Thank you.
Normally, that's not enough of a reason to ask for expeditious. Unless the best reason to ask them to expedite if someone is sick, someone is dying, the qualifying relative is very sick, something like that. But normally, they make mistakes all the time. I mean, I see it. We kowtow to them. We kiss up. We say, "I'm sorry." Here is, even though it's not my fault. I normally don't, because we need them to give me my visa. So, but that's my advice. But you can try it, I guess, because we know that we worked together for 45 years with them. So normally we don't call them out. That's always my position, unless it's so egregious. And normally that we don't even do an email. I just call them and say, "What's going on here? Are you having a bad day or something?"
Okay, thank you so much, Ms. Wong, for your answer. Don't forget that the attorney Margaret W. Wong has been working on this field for over 45 years. She started in 1977, but she has never left the immigration field. She has never given up about this important career or this important area of the law, which is the immigration law. And some people get discouraged or they don't want to keep working on this because it's very emotional. And then if you are a person that needs an advice from an attorney, you need someone that is uh, strong enough to keep up with your case, to let to know what they need to do in order to get you an immigration relief. And some people just don't do it because they don't trust, or they hire an attorney that they will do it by themselves. And then some attorneys just get too busy, or they cannot um, find the way to do something because they have never done it. And I can tell you, Miss One has had all kinds of cases in the office, starting from asylum cases, 42B, or cancellation of removal, many cases, Miss Wong. And this is the success of the law firm. That is not only Ms. Wong, it's a bunch of people that are working in your immigration case. So thank you so much, Ms. Wong, for everything you do in order to help our people. The next question says, I filed AR11 last year online, and the status says it's good, but uh, I haven't done it by paper. Can I do it now by mail?
Yes, yes, you can do it by mail. Always attach a receipt notice or something like that. It doesn't hurt. Yeah.
Okay, thank you so much, Ms. Wong. So this next question says, "Hi, I am a teacher in my country. I'm a teacher in the in this high school, and I am in the United States currently on a tourist visa, and I would like to know if being a teacher could be a good thing to file for a work visa in the United States."
It depends on what licensing you have. In America, you could do an H-1B for teacher unless you're from Mexico or Canada. Then you can do a TN visa, but you have to go under the job descriptions and look as a teacher, like a nurse is, but you have to be licensed with NCLEX for nursing. So it depends for H-1B, but some high schools or grade schools or universities, they require licensing for teaching. So if so, then you need that license to teach that for the H-1B. You start working on H-1B sometime in February. So by March, you register for the lottery, and by April 1st, you file the H-1B registry. And by April or May, you find out if you're into the lottery, then you start filing for H-1B effective in October. So for now, it's already May, so you need to wait till next year to do the H-1B visa.
Okay, thank you so much, Ms. Wong, for your answer. Don't forget, you can call the phone number 216-279-3984, 216-279-3984. The next question that is coming in is, this person says, I am from Venezuela. I couldn't file asylum before tomorrow, that is May the 13th. Um, I entered on a tourist visa a year ago. The year is completing tomorrow. What are the consequences that I file the asylum 1 or 2 weeks later after the fulfillment of the year?
There's a question on the 589. I think it's on page 5 or page 6. They ask if you is this a 1 year filing? If not, why didn't you file within 1 year? Then you explain the reason you have post PTSD, or whatever reason that you gave. It doesn't mean you could not file, even though it's more than a year or 2 years. It only means that we have to give a reasonable um, answer why. But the earlier you can file within the year, the better.
Hey, thank you so much. Some questions are coming to the show after I read them here in the system. So, Ms. Wong, let's say that one person is filing for TPS, and but they also have their children that are U.S. citizens, that they became U.S. citizens for some reason. Um, is it okay to file for the green card of the parents when
Yes,
they get the TPS?
absolutely. The way to do it, Trump said any TPS parole after August of 2020, no more adjustment of status. Biden came back now and say, as long as you have parole after TPS, you could adjust status. In the Sixth Circuit and the Ninth Circuit, which is Ohio, Kentucky, Tennessee, and Michigan, uh, there was a time saying that you don't even need parole as long as you have TPS, you can adjust status. U.S. Supreme Court came in and say you need parole for TPS to adjust status. So the answer is as long as you have a child over 21 and became a U.S. citizen, has to be over 21, and you have parole after you got TPS, absolutely you can do adjustment of status.
Okay, thank you so much, Ms. Wong, for this answer. And well, we have some other questions here. Let me see if I'm not skipping any questions because we have a bunch of them today. And yes, this person is asking, what is the difference of doing the regular process for an I-130 and the adjustment of
That's a good
status?
question. I-130 is the visa petition. The fact there's only 4 visa petition: I-130, I-140, 526, and 360. I-130 is the family petition to allow you to do adjustment of status. Adjustment of status is the 485, the change of status from a student to a green card, from a K-1 to a green card, from an H-1B to a green card. So combining the I-130 and the 485, you get the green card. It could be an I-140 and the adjustment of status. It could be for 526 and adjustment of status. So combining both of them, you got the green card.
Thank you so much, Ms. Wong. And this person is asking, um, we sent our documents to renew the work permit last year in September, and we have not received nothing. I am scared of losing my job.
Okay, I'm glad you asked this question. Just about 2 weeks ago, and we announced it on this Facebook page, that President Biden announced a 560 days extension. You should have got, if you filed the work permit extension last year, you should have gotten the 180-day extension. With that extension, you just need to show the boss on the driver's license the CIS automatic extension for the 360 days. But if you did not get a receipt, I would immediately file a new one. But you should have gotten a receipt. But if you didn't get the receipt, I would check, did you file the work permit extension with a money order or personal check? Call the bank and go back there where you buy the money order or talk to the bank. At the back of the check, there should be a case number. With that case number, you can call immigration and say you lost the receipt. Once you get the receipt, show the boss, you get automatic 360-day extension. And congratulations.
Thank you so much, Ms. Wong, because a lot of people are scared about this decision. I mean, not about the decision, but they are scared about the delays that this is going on. So the next question, Ms. Wong, is let me find it here. Um, Panka Mahla is asking, is it possible to do labor certification if I filed asylum after 1 year of being in the United States?
It depends on when you came to America. For example, you came on a tourist visa, you filed asylum after 1 year, so you had done an extension of tourist visa because employment-based labor cert, you always get the permit. Barring unforeseen circumstances, the perm should be approved, I-140 should be approved. The question is, could I get a green card because you may be 180 days out of status? Which means that as long as you're less than 180 days out of status and you have not illegally worked, within that 180 days or before you ever got that work permit after you file asylum, you should be able to get the green card. I think the question should be, if I'm out of status for less than 180 days, can I still get a green card through the perm? And the answer is yes. The test is on where you're out of status for that 180 days.
Okay, thank you so much, Ms. Wong, for this answer. Ms. Wong has 9 offices in the United States, and these offices are 100% functional. So you can come to the office in Atlanta, in Chicago, Columbus, Cleveland, Memphis, Minneapolis, Nashville, New York, and Raleigh, North Carolina. And the phone number is 216 279 3984. 216 279 3984. So, Ms. Wong, this next question is very interesting, actually, because this person says, I am interested in filing for the NIW, National Interest Waiver, but I don't speak English. Can I file for this if I don't speak fluent English?
Absolutely. Everything has to be translated into English. You put the English translation on top, the Spanish or the Chinese at the bottom. Absolutely, you can file it. You don't need to speak fluent English. It's not like a citizen test. You have to speak English to pass the test. For NIW green card, you don't need to speak English.
Okay, thank you so much, Ms. Wong. Well, our time is up for today, Ms. Wong, and thank you so much for each one of your answers. It has been really useful for everybody that has been asking the questions. And if you are in one of the cities that Ms. Wong has offices, or you are about 1 or 2 hours distance from this office, you can travel, you can drive all the way to the office, and it's worth it to do it. It's worth it to go and see the attorney face to face, ask some questions, and then you will feel better because you will know what you can do or what you cannot do in your immigration case. So thank you so much, Ms. Wong, for your time. I'll see you next week. I hope you get well soon, and just drink some tea. That's what I'm doing in this cup. I have some tea, and this is what we need to do. We need stay to stay healthy. So thank you so much, Ms. Wong. And next week I'll see you in a very, very, very good condition. Thank you so much.
Thank you. Thank you, Mr. Juan.
Thank you. And for everybody who has joined us today, thank you so much for joining us. The phone number is 216 279 3984. 216 279 3984. Attorney Margaret W. Wong, the expert in immigration law for over 45 years of experience. Thank you, and see you next time.